we are starting the afternoon session. I would like to introduce the lecturer of our afternoon session. We have with us Dr. Nilüfer Oral. Dr. Oral is originally from Turkey, but she's now based in Singapore and works as a director at the Center for International Law at the National University of Singapore. The topics of her lecture today are law of the sea for the first half and the impact of climate change on international law for the second half. Please.
So, good afternoon to all of you. It is really for me a tremendous honor to be here. I don't think, can everyone hear me all right? All right, very good. It's a tremendous honor for me to be here today with all of you, and particularly in Tokyo. So first of all, I extend my sincerest appreciation and gratitude to the Ministry of Foreign Affairs of Japan for inviting me to this very prestigious international law seminar. And I get to spend quite a bit of time this afternoon with you. And I hope that you will not be shy, ask questions, because you may get tired of listening to me after a while. But I hope to give you I hope this will be an interesting lecture for you. I don't know, I have your backgrounds. Many of you, of course, I think, from foreign ministries, government, from the region. I'm actually working in Singapore now, so I consider myself from the region as well, although from Turkey, which is also a member of ALCO, actually. So I don't know how many of you have had law of the sea background. Can I get a show of hands for those who... Yes? Okay, very good. All right. All right, okay, here, there, all right. Not a lot then, not a lot. Great, all right. So those of you who know law of the sea, feel free to add your views as well. But on the other hand, I look forward to introducing many of you to a topic that I hope you will find as interesting and important as I think it is. So the way I have structured this, not really knowing, I think one of the hardest things about teaching is gauging time. And so we have right now till 3:40 for the first part. So I'm going to give you some background information on the law of the sea itself. But not so much, I don't want to be too technical actually, but instead to kind of convey what I think makes the Law of the Sea Convention such an important convention. And then it will also give us a bit of a background as we go into the climate change aspects. We may get into that earlier, the climate change aspects. We'll see. I'm going to just not plan too much and see how we go. So what I will be looking at is Law of the Sea, new and old challenges. And I think this is what makes the Law of the Sea so fascinating. And I hope you will see that. It's been around for a long time, the Law of the Sea. Oops. When we speak about the Law of the Sea, I have to say, I mean, maritime issues have been around for centuries. But traditionally, when we're talking about Law of the Sea, inevitably we'll start with the Dutch Hugo Grotius. You're all familiar, perhaps, if you've done international law. It's a Western view, of course, Hugo Grotius. Nonetheless, the reason I like to put it there is that because it all started, the road to modern international law of the sea, it all started in the Strait of Singapore. If you've ever flown into Changi Airport, that is the site where the famous Portuguese ship carrying cargo was attacked by the Dutch. Then it was the East India Company, and they hired Hugo Grotius, then only 21 years old, to defend. And he wrote his famous defense that became the basis of the modern law of the sea for freedom of the seas. So today it's an airport, but it has an historic, or it's where the airport is built on the coast of the strait. But here you see there's a very, to get to the point of the United Nations Convention for the Law of the Sea, it took a long time. International conferences were held, even before 1930, but I don't want to go into that much detail. And one of the big issues that remained unresolved until the 1982 Law of the Sea Convention was the question of the breadth of the territorial sea. And it used to be what they call the cannon shot rule. And that's because they said, okay, however far you can shoot your cannon, that's where your territorial sea is, because that's how far the coastal state can defend itself. But that changed over time because of technology. Ships could go farther. They started going, closer to other states' coasts. So it became increasingly an issue. And so finally, in the International Law Commission, I know my dear friend, Phoebe Okawa, spoke, I guess, yesterday about the International Law Commission. And so at that time, the International Law Commission, one of the very first topics that was given to address was on the law of the sea, territorial sea, high seas. And in 1956, they adopted what became the basis for what we know today as the Geneva Convention on the Law of the Seas, 1958 Geneva Convention on the Law of the Seas. And that was at the first Law of the Sea Convention conference. So the commission prepared the draft articles, which served as the negotiation basis for states. And states then met in 1958 in Geneva, and they adopted these 4 conventions. Now, one thing that's important is it was a very different UN in 1958. And I think you must keep this in mind when we eventually get to the Convention on the Law of the Sea that is now currently in force, and many of your countries are parties to. But again, the territorial sea, how big would it be? 6 miles, 12 miles? That remained undecided. So another international conference was held again in 1960. And guess what? The breadth of the territorial sea remained outstanding. They were unable to decide by 1 vote. Can you imagine? 1 vote. They were 1 vote for 6 nautical miles. So I often think about how history would have been very different if they had made that 1 vote. And I think it was US or Canada anyway. It would have been very different, so we would not have had maybe the 3rd conference on the law of the sea. And that is a revolutionary conference, because as I hope to show you, what came afterwards was very, very progressive and brought in a lot of innovation. First of all, remember I said 1958, the UN was very different. It was a different world in 1958, because then you still had colonization. But that's changed by the time the negotiations started for the 3rd conference on the law of the sea. And how did that start? Well, if you know the history of the law of the sea, here, this gentleman from here is from Malta, Ambassador Arvid Pardo. And at that time, it's funny, now, time has changed. Malta now is part of the EU, but at the time, Malta was a poor island state. It was a developing state. And Arvid Pardo was so concerned that because of the technological capacity of the developed states, who were increasingly able to go deeper into the ocean, he was very concerned that the developed states would access the deep seabed and the polymetallic nodules also known as purple potatoes because of how they look, and leave the developing world behind. So he gave what is now considered one of these famous speeches before the General Assembly that went on for hours, apparently, about his concerns that the developing world just coming out of colonization, this is the new independent states emerging, should not be left behind as the world moved forward with technology. And so this is what launched, and you may all have heard of this, the common heritage of mankind. He was very concerned about access to what we know the seabed. It's become big news now, the seabed and those minerals. And so he launched what was then the Seabed Committee, and that turned into the third conference on the law of the sea to renegotiate the 1958 conventions, which really were fine, but they came from a different time and a different UN, frankly. The UN was changing, the membership was changing. So you had Malta. All right, who are these? These are the leaders. There are more, but these are really the men, unfortunately not many women at that time, the men who made UNCLOS. Tommy Coe, he's legendary. He's my mentor, he's my friend, he's amazing. He's 88, but still very active. He was the second president of the Law of the Sea Convention. He came after Shirley Amarasinghe from Sri Lanka, who was the first president, unfortunately passed away during the negotiations. All right, so you have Singapore, a small developing island state, you have Sri Lanka, and then you have the famous Satyanandan from Fiji. He played a very instrumental role in developing negotiations. One, for example, the Straits regime, also the seabed. He later became the first Secretary General of the International Seabed Authority. So I put this up because this is what changed. Now we have the newly developed states, including ALCO, right? States from ALCO were extremely active, very influential in shaping what later became the Law of the Sea Convention, which we call UNCLOS. And this is important because I consider UNCLOS to be the first convention adopted really by this new UN membership of newly independent states. And it shows. So here I just want to also focus a bit on ALCO. So you know ALCO is an important organization, Asian African Legal Consultative Organization. And ALCO, the members of ALCO played also very active, very influential. And they contributed very much to development of new concepts. And later I'm going to go over more detail what those new concepts were. There's lots of them. It's over 300 articles in the convention. It's massive. One, which is very important, was a completely new maritime zone. We know the territorial sea. That's what it used to be. In the old days, it was you had your internal waters, territorial sea, which they couldn't decide how big that would be, and then high seas, okay, open to all. It was actually ALCO, Kenya, who originated this concept of an exclusive economic zone, and it had to do with fisheries, of course, because what was happening is that you saw more and more technologically advanced shipping who were able to go closer to the coastal areas of many of these countries and fish. Right? So these countries wanted to protect their fishing rights. And that's really, I mean, the exclusive economic zone was once high seas, open access, and it changed that. And so it was Kenya and ALCO who were extremely important in doing this. And if you know, have you been involved in negotiations? You know how difficult it is to negotiate. And you know particularly how difficult it is to bring in new concepts. That's what makes the convention so remarkable. Again, the notion of archipelagic state, archipelagic waters, and sea lanes. That didn't exist. And Indonesia, Philippines, the archipelagic states, for many years have been trying to push for this. And finally, they succeeded in the convention. So, and very important because that gave them sovereignty over an area which they did not have before. Landlocked states, and we have some landlocked states. Again, the rights of landlocked states had never been addressed. And again, this was an issue particularly for many of the newly independent developing states at that time. And now we have a complete part on landlocked states, although often, I have to admit, we don't do enough on this. And I think it's an issue that we do need to address more. And of course, the big one, common heritage of mankind. This was launched by Malta. This was critical for the developing states at that time. The whole notion that no one state can exclusively have ownership, access, the benefits to resources of a vast area that we know as the seabed. And that was to be shared. The notion of common heritage of mankind wasn't new. In fact, space, the moon and space are subject to the common heritage of mankind principle. But the convention gives a very, very detailed regime. There's a lot. I'm not going to go into detail unless we want to talk about it. But the essence of the common heritage of mankind means that even though right now the United States is claiming it can go and do independent seabed mining, because this is a big issue right now, the whole idea is no one state can do that. That it had to be governed collectively, which it is. There's a seabed authority. All member states of the Law of the Sea Convention are ipso facto members of that authority. They govern together. They decide together. And eventually, so far the exploitation hasn't started. There's exploration. But once that exploitation starts, then there's going to be a system for benefit sharing of that. So all of this was very important, and ALCO played a very important role in this. All right, so again, when we look at the convention, what are the, I kind of already mentioned this, but what were the big issues and the developments? One, of course, for the first time, finally, after decades, they agreed on the breadth of the territorial sea to what? Does anyone know? 12, that's right, 12 nautical miles. It wasn't by consensus, though, because not every state agreed. I have to say that because my country, Turkey, didn't agree to this. But it was enough to have the majority vote. A completely new regime for straits. Before, straits were under the territorial sea regime, but because once you did this 12 nautical mile extension, it would make territorial sea into areas that were once high seas. And particularly then, the big maritime powers, the superpowers with their warships and submarines, were not happy about that. So remember I mentioned Satyanandan. He was very instrumental in this. And so part 3 of the Law of the Sea Convention is entirely on straits. We never had that before. And it's complicated. There are different categories of straits that didn't exist before. Archipelagic waters, again, something that didn't exist before. It's a complicated formula, and when we get to climate change and sea level rise, we'll talk about that a little bit more. But again, this was revolutionary. Now, archipelagic baseline, archipelagic waters gave to archipelagic states who met the formula much more control and sovereignty over their waters. Again, the common heritage of mankind, I just talked about that, and dispute settlement. So under Part 15, there had been compulsory dispute settlement before, but nothing as complicated and detailed as Part 15 of the Law of the Sea Convention. And again, if you've done negotiations, it's really remarkable that they were able to come up with the detail. I don't think they could do today, to be quite honest, on the dispute settlement, because it includes, of course, arbitration, includes conciliation, compulsory conciliation. And the only one to date has been the Timor-Leste and Australia conciliation. So what it means basically is that once you sign on, ratify the convention, you have ipso facto agreed to compulsory jurisdiction, but you get to choose. Do you want ITLOS? Do you want ICJ? If you don't choose anything or the two sides aren't the same, by default it's what you call Annex 7 arbitration. So it gives a whole, many options, and also created a tribunal as well. So here I have a list of most of the different parts of the Law of the Sea Convention to just show you the innovativeness of it, that in the 4 Geneva Conventions that were adopted previously in 1958, this did not exist. For example, and this is something I know we have, Mr. Paul Reichler here, he's one of the, on the continental shelf beyond 200 nautical miles, did the famous case on that. So it created new maritime zones. Exclusive economic zone was one we already mentioned, the area is another, but also the whole notion of the continental shelf, since the famous Truman Proclamation, and it was also codified in the 1958 Geneva Convention on the continental shelf. It was 200 nautical miles from the baseline from where the breadth of the territorial sea is measured. But this went further, right? And it's a maximum of 350 nautical miles. There's a whole complicated scientific methodology for this. They created this whole new commission to have that. But it was important also because always in mind was this, I'm looking at the center here. Think of the center as the seabed, the international seabed, the area. So they really wanted to have clarity on where that area started and ended. But, my goodness, they didn't realize how many claims there would be for this extended continental shelf beyond 200 nautical miles. And I think now the committee on the Commission on the Continental Shelf, Commission on the Continental Shelf will be working for quite many years ahead of us on that. But that's something completely new. Also, I have to say, and we'll talk a little bit more, and this is important, we'll talk a little bit more about this as I go further on. But here we have what I say, Part 12. This is the first legally binding global instrument for protection and preservation of the marine environment. The obligations in that part are very clear. We'll talk a little bit about those. They've come up in advisory opinions recently. It's Part 12. There are many provisions on this. And today, if you can believe it's over 40 years now, Part 12 still remains as the most robust, globally binding instrument on protection and preservation of the marine environment. So again, showing how at the time this convention was really not simply breaking barriers for that time period, but for now as well. Also, they codified marine scientific research for the ocean. Cooperation is absolutely essential. It's a common thread that runs through all of this convention, and particularly emphasizing cooperation to the benefit of developing countries at that time. That was one of their main concerns, was access to technology, capacity building, scientific research. And it remains that, because we're going to talk about the BBNJ agreement as well, it still remains that way. Again, marine technology, and then we talked about the dispute resolution. So, as you can see, this is a convention, even though it was negotiated, it was adopted over 40 years ago, but it was negotiated between 1973 and 1982. And I think we always are asking the question, has a convention withstood the test of time? Is it still fit for purpose? And it has been tested and continues to be tested many times over, and climate change is one of the big tests for that. And we will get to that. But my opinion is that the convention is still really an amazing convention. It addresses so many issues, and I really don't think that today, if we were to sit down and negotiate, that we could quite have the depth and the scope of such a convention for the ocean, because we know how much of the Earth is ocean? 70%. 70%. So it's very important. These are just some of the bodies it created. Also, additional instruments were adopted to it. So today there are 170 ratifications. On this, of course, the issue of the common heritage of mankind, access to the seabed resources, was not an easy negotiation, particularly with developed countries. And so they were not happy entirely with Part 11 on the area. And so they had to negotiate another agreement for the implementation on that in order to agree then to sign on to the convention, which they did. Then also, one issue that was covered has to do with fisheries, always important, but there was a gap concerning the governance of what you call highly migratory, like tuna, right, and straddling fish. So in 1990, I think it was 94, 95, they adopted this implementing agreement. What we mean by an implementing agreement is that it's an agreement, binding agreement, negotiated, but is under the convention. So it's meant to basically expand upon the convention where there are gaps. Most recently, and we'll talk about this, is the agreement, very long name, I have to say. There should be some kind of rule. You can't make conventions with such long names. Eventually, we end up making acronyms. Agreement under the Convention on the Conservation and Sustainable Use of Marine Biological Diversity of Areas Beyond National Jurisdiction, otherwise known as BBNJ. Exactly, BBNJ. Much easier. Pretty amazing. I am going to get to BBNJ. Pretty amazing. Already 132 signatures, and it is on the brink of ratification. Pretty good. Yeah, I see we have BBNJ fans here. Excellent. We'll get to that. Well, okay. All right, so that was just kind of an introduction for those of you who may not be familiar. But again, to me, it's not just being technical, it's understanding why this convention is important. What it brought to international law. And it brought a new set of voices, right? And so I think sometimes we have to think about this in terms of negotiations and interests. But anyway, so now I will focus on the part 12. Marine environment. Before I do, though, maybe I should just stop and say, any comments? Any questions on the convention? No? No?
If there are any new cases, I mean, if there are any new cases currently under discussion, that involve this convention.
Oh, you mean dispute cases?
Yes.
Oh, yes. There are, mostly they're maritime delimitation cases, but we had recently one advisory opinion that we'll talk about later. But of course, we have Paul Reichler, who's probably handled most of the cases that have been brought under the convention. A lot of them are maritime delimitation cases. Some go to ITLAs, but a lot go to arbitration. Anything else? All right, we ready for marine environment then? Let's go to that. That's my favorite topic, actually, because at least you get to show nice pictures. I was always jealous of the scientists. They always had good photos and pictures. You know, the lawyers, what can we show? You know, so if you do so this is a good topic. Okay, so as I said earlier, part 12 on the protection and preservation of the marine environment. Really, again, at that time, there was nothing really quite like it, and still isn't. And so if you look at the language, because if you start looking at instruments for the environment in general that were adopted later, it's not as strong, in my opinion. So Article 192 is like the overarching general obligation. And what it says is states have the obligation to protect and preserve the marine environment. It's pretty clear. The states have the obligation. It doesn't say, oh, states shall do their best to protect the environment. You know, it says they have the obligation. Article 194 states shall, and we know that's very important language in law, states shall take individually or jointly, as appropriate, this is now a little bit soft, you know, that as appropriate, all measures consistent with this convention that are necessary to prevent, reduce, and control pollution of the marine environment from any source. I want to underline that. Any source. Now, as we learned, that Article 194 has been interpreted to mean what they call a due diligence obligation. So you may have heard the difference between obligation of result, obligation of conduct. So basically, due diligence means that states are to do their utmost, their best, in this case using best available science to protect and preserve the marine environment, take all necessary measures. This is one on the advisory opinion we had from ITLAS on this. But it doesn't mean that you're actually going to be successful, and that is an obligation of result, meaning that you would actually have to stop pollution versus your conduct has to be one of due diligence. Anyway, these are the legal technical requirements. But what's important here is that states are required to either individually or jointly. And now we have many, I have to tell you, there are many regional seas under the United Nations Environmental Program for cooperation to address in different seas, the Mediterranean, Black Sea, they have for the region PEM Sea. So a lot of methods, a lot of ways that states are also cooperating, as well as through the International Maritime Organization. But what's really important is that at that time, remember, this was negotiated in the 1970s, actually. Even though the main concern of pollution was from ships, they actually thought about other sources of pollution, like atmospheric pollution. And that became very important later on as we get to climate change. But so the convention says all sources, there's no limit. Vessel source, land-based source of pollution, I'm going to say right now that the convention still is, amazing to me, the only global instrument that is binding addressing land-based sources of pollution. And we know that land-based sources of pollution is the principal threat to the marine environment. And that. Anyway, so, but let's see, what were the main threats to the marine environment, I keep saying at that time? This is a photo of the infamous, and if you know IMO, anyone work on IMO? The International Maritime Organization, which is headquartered in London, and it's the principal UN agency for regulating global shipping. This is the Torrey Canyon. And the Torrey Canyon was an oil tanker that basically grounded, split in two. This was 1960s, 1967, in the Northern Sea. And it was the first major oil spill. And I have to say at the time, it was in the high seas then. And so under international law, and that still is the rule, without the permission of the flag state, meaning the state under which the ship is registered, another state cannot board, cannot interfere, can't do anything to that, right? Well, but in an act of sometimes called necessity, UK actually bombed the Torrey Canyon to sink it as a way to stop it from further pollution of the marine environment. I don't know. I don't know how sinking it actually helped, but it became important because that led later to the creation of the environmental division of the International Maritime Organization, the Maritime Environmental Prevention Committee, the Legal Committee, and a whole bunch of conventions, including one which allows a coastal state to intervene on the high seas. And there's a whole separate convention on that. So that's the Torrey Canyon. The Torrey Canyon, the accident to launch a whole new area of law, actually, and a whole new industry of marine pollution prevention. And for a long time, this has been the big issue for the marine environment, ship-related pollution, whether it be accidental or also operational. There's lots, one thing, and I didn't put it here, if any of you have been involved in shipping, ships have to change ballast water. And this is something they've done from time immemorial, to keep the balance of the ship. In the ancient days, they used to fill it with rocks, apparently, but now it's water. And what happens is that the ship will take water, let's say, from one part of the world sea, and then navigate to another part of the world sea and discharge that water. But guess what? It's bringing all kinds of invasive alien species. And if you ever want to watch a scary documentary, it's one that the IMO did called Invaders of the Sea. And it's really frightening to see, not just in the sea, how those species coming from far away can creep up on the land, actually, and clog up pipes. It's amazing. Anyway, I divert. Dumping also. So those were really the traditional, but that's what I'm saying. When you look at the convention, it wasn't just limited to these vessel sources of pollution. It was expanded enough to take into account other things. This is land-based, example of land-based pollution. Well, all right, that was back then. What about now? Things have changed, and that's why we ask that question. Is the convention still fit for purpose? Can it address the new challenges? And sadly, really sadly, there are still many new challenges, risks to the marine environment since the adoption of the Law of the Sea Convention, since its negotiation. Well, one thing that the convention didn't take into account was biodiversity. So the Convention on Biodiversity was adopted in 1992, 10 years later, because it was a concept that had not really been brought into the international attention until the late 80s, 90s. So there's no mention of biodiversity, right? Another phenomena that the convention didn't address is something we know now, which really is a huge problem for many states, illegal, unreported, and unregulated fisheries. So there is no mention of this. But I don't have it in here, but I will then just very quickly, just to give you an example, how the convention has proven to be resilient, or shall we say dynamic. In 2014, a commission of several West African states brought what was the first request for an advisory opinion to the International Tribunal for the Law of the Sea. And it had to do with what are the rights and obligations of foreign flag states, vessels, engaged in IUU fishing in the exclusive economic zone of another state, right? But there was no IUU fishing. It's not in the convention. It had been taken up later on by FAO. But if you go back, again, I didn't put the details here, but I will say this. The tribunal showed, through interpretation, taking into account developments that had happened, they were able to interpret provisions of the Law of the Sea Convention, specifically on the obligations of flag states to exercise due diligence, to include IUU fishing. But it's not in the convention. Is there a problem with that? Or should we be really strict in the convention? What do you think? Do we have a... Oh. I don't want to hear myself, but I know it's a bit technical, so I'd love to hear your views. Yeah, there's nothing in the convention about IUU fishing, illegal, unreported, unregulated. It's something that happened in the 90s. So please, and your name?
My name is Amira.
Amira.
Yeah. My point is that convention will be more compelling, more enforcement to the law than other means. Unless you have something to tell us about the convention, about the commission, or the formation of the new formation.
Do you think that the convention can be adapted to new... No?
Without amendment?
Without amendment.
Unless you have wide interpretation.
Unless you have wide... this is one of the issues, how far to interpret. And we will be talking about this when we get to climate and sea level rise.
Yeah.
Should the courts have to be restricted only to the black letter law, that's the highly positivism? Or can we take into account changes that have taken place? So long as let's not exaggerate either, but yes? Here, let me take. Okay, we have another one.
Thank you very much, Professor. It's a nice presentation. I count myself among the people who are lovers of the UNCLOS. I am a fan of the UNCLOS.
Oh, great.
It was a codification. It has become customary international law. I don't wish to see the UNCLOS amended. I think the solution is to, like the BBNJ, to come up with new treaties that extend on the provisions of the UNCLOS or cover new issues that were not covered by the UNCLOS. But because the UNCLOS have become customary, even the United States, for example, is not party to the UNCLOS, and they respect the provisions of the UNCLOS. So at the time, like you say, it was many years ago, at that time, they made provisions for issues that were very key, especially for maintaining the peace at the sea. And then they went over into issues like environment and all that. But the things that were provided in the UNCLOS, I don't think will never die, will never be extinguished. Thank you.
Thank you. Yes, and I think many share your view that we should not amend UNCLOS. It'd be very difficult anyway. Amendment of conventions, virtually, really very rare and very difficult. And so one way, of course, is through implementing agreements, but another way is interpretation. And it's just a question of, how far we can go with interpretation. So was there anyone else who wanted to make a comment? No? We'll continue. So again, we're looking at what has happened after 1982. One thing, marine protected areas. Now it's familiar. We've all heard about marine protected areas. Not so common back then. But something that was interesting is after UNCLOS was adopted in 1982, the IMO, the International Maritime Organization, realized that shipping was an issue for the marine environment, a threat. And so they developed something that is called a particularly sensitive sea area. And so through the IMO, states can declare part of EEZ, it's never been done in the high seas, but why not, as a particularly sensitive sea area, and recommend to ships, avoid that area. For example, one of the first one they did was for the Great Barrier Reef. That was the first one, particularly sensitive sea area. And you can see, do you want tankers going through there? So you say, if you can avoid that, that would be, good. That was outside of UNCLOS, so measures can be taken. But UNCLOS actually foresees this because it does require cooperation. And we talked about either do things individually, or express mention is made to the competent international organization in the singular for such cooperation, and that is the IMO. Another thing that came up after UNCLOS, this whole notion of sustainable development. The Brundtland Report, 1987. Now, of course, we have the Sustainable Development Goals. And there's SDG 14 for the ocean, below the sea. That didn't exist back then. Marine genetic resources. Didn't know about it then. This is something that since has come up. And now, of course, it's one of the main drivers of that BB&J agreement, marine genetic resources. But it is a multi-billion-dollar industry. Shampoos, creams, medicines, a lot of things are being developed from marine genetic resources. And this will go back to the whole issue that Arvid Pardo was concerned about, is that the technologically advanced developed states, will they have an advantage, over the other states? And this came up again with marine genetic resources. Plastic marine pollution. It's a land-based pollution. But then we didn't, now the sea is just choking in plastic, right? Noise pollution. How many of you are aware of noise pollution from marine mammals in particular, whales, dolphins, how impacted they are? And of course, climate change. So these are all the threats that when the Law of the Sea Convention was being negotiated, that the states were simply not aware about. It didn't exist then. So this is showing you noise pollution, but it's also a pollution. It comes from, for example, when ships are doing surveys, seabed surveys, and it could be military, usually it's the military doing that, but it could be also for other reasons, and they send out these ping, ping, ping sounds, scientific research. But it turns out that these are all impacting. We've learned so much more about whales, for example, and their auditory system, how they communicate. And there have been, these whale landings, massive whale landings, and can be attributed to the fact that they've lost their own ability to navigate because of noise pollution. So this has been taken up seriously. But it's not in the convention. But remember, what does the convention say? All sources of pollution. So there you go. And now plastic pollution. That has become really, at the time, wasn't the extent it is. So just a little bit. I don't know if any of you are following the plastic the plastic treaty negotiation. Is anyone involved in that at all, following it? It's interesting because, now you see, UNCLOS has a lot of implementing agreements. And I was actually part of an initial study done by UNEP to understand the existing international framework for addressing marine plastic pollution. There are different names, though. Marine plastic pollution, micropollution, microplastic particles. But basically, it's the whole idea that plastic is entering the ocean in one way or the other, mostly from land, but also from fisheries as well. So you'll see those photos, of course, of entangled turtles, dolphins. It's because these fish nets, and some of these fish nets are massive. We haven't even gotten into fisheries. Massive fish nets. And so they get entangled, but they're plastic. Or they throw their fishing gear into the ocean. Sometimes the IUU fishing I talked about, they're trying to escape, they just throw or leave their gear behind. This is also part of the plastic pollution. Most of it is coming from land-based, and land-based where? Rivers, all right, massive. So I was involved initially in a UNEP to kind of do a survey, examine, how to address this. Do we need even a new instrument? That was one of the questions. Is there a need for a new plastic treaty? One. Second, okay, well, we have a lot of regional, I mentioned earlier, regional seas programs for the Mediterranean, Black Sea, Caribbean, Arctic. Everywhere, all the seas practically have some regional sea program where the states cooperate. But there are different levels of governance. Whether that would suffice, let's just do it there. But then you have parts of the ocean that aren't covered. Whether it should be under the law of the Sea Convention or separate. And the way they went was they created, after 2016, the United Nations Environmental Assembly. Have you heard of that? United Nations Environmental Assembly. It's like the General Assembly at the UN, but it's for the environment. And so they decided, at that assembly, states decided that they would adopt a standalone treaty. But what's interesting, not under UNCLOS. So it's not under the United Nations Convention on the Law of the Sea. Why that is? Because really, the thinking was this, is that the source of marine plastic is land-based. And even though UNCLOS does say, it covers land-based sources, there's no doubt about that. But I guess I felt that it made more sense to directly address land-based through a separate treaty under UNEP versus under the convention, even though it's the marine environment that is really the recipient, the depository of, I can't tell you how many millions of tons of plastic go into that. So there you are. So here, Law of the Sea Convention is not involved. Instead, they have started in 2022 with a resolution at UNEA, and they've had 5 sessions. They split the 5th session in 2. The last one was in Busan, Korea, and the next one will be in Geneva, Switzerland. So it could have been an implementing agreement. We're talking about implementing agreement, but instead it's going to be standalone, and we'll see how it will go. Will it work? And that. So in this case, the Law of the Sea Convention was kind of left out. All right, now let's get to BBNJ. BBNJ, the famous BBNJ, areas beyond national jurisdiction. So this is the high seas, right? This area, vast area, this huge, vast area of ocean where no state has competence other than the flag state, right? So under the law of the sea, international law, on the high seas, the flag state, and that is the country, the state under which every ship has to be registered under a flag. It's a whole big issue, so I won't get into this whole, whether there's something called flags of convenience, but let's just put it this way. Not all flag states are the same. Not all flag states are equal. Some flag states exercise more control over administrative control over their ships than others, and this is the issue. Not every flag state is a party to all the IMO conventions as they should be, or doing the necessary surveys or certification. It's a big issue. And so the problem is on the high seas, it's only the flag state. The coastal state can't do anything. It's high seas, it's beyond national jurisdiction. There's no coastal state has jurisdiction there. And the concern was that this is an area, vast area of the sea, that was degrading. A lot of it had to do, and this will come up when, during discussions about this BBNJ, had to do a lot of it with fishing, trawling, fishing techniques. I mean, if you see, you have fish nets that are kilometers large. I mean, they're huge. Or, I don't know if you've ever seen a deep sea trawler. They just completely destroy everything, all habitats, everything that's on the seabed, gone, finished. And there is really no control over that. You have some UN, resolutions and that. So there was a concern that this area was really neglected. There was a need for, started in the 1970s even, a need for marine protected areas. So that was the initial understanding. We need marine protected areas. And so this launched, it started in the 1990s. So this is an example of how long it takes to address a problem that has been known scientifically. But nonetheless, I think what's important that states eventually do cooperate. And they do come to find some solution to the problem. So in 2017, after workshops, I mean, a lot of things were happening during this time period. I have to say civil society has played a very significant, influential role, which is another issue, is the role of civil society. But in 2017, the General Assembly adopted a resolution to convene an intergovernmental conference, basically to negotiate this new treaty, an implementing agreement under the Law of the Sea Convention. So I have to say, again, coming now from the Commission's perspective, and I know that Professor Okawa talked about the Commission, some people said, well, again, the Commission was bypassed. They had done the 1958 Geneva Conventions, but no more. It's true. But that's all right. This is something that is under the Convention for the Law of the Sea, so I don't think there really should have been a role for the Commission. All right, so here finally, we have, this is a photo, I put two because this is Ambassador Rena Lee, president of the conference that successfully adopted this new BBNJ agreement. She's from Singapore, and I have to say, finally, we have a woman as well. So important, so important. So we celebrate that. And she did a fantastic job. I'm a bit biased. I know her well, but I have to say she really did. For those of you involved, that was a very difficult negotiations. Not always, I mean, we were just actually speaking recently, and I agree that some people were saying, BBNJ agreement, this is pie in the sky. There's a lot of cynicism. There's always a cynicism sometimes. But it turns out that states took it very seriously. And I think it's an example in this time where multilateralism is being questioned. It's a wonderful example where states have identified a problem that is really a common problem. These are problems of common concern. We talk about, common heritage of humankind, we say now, but so is this. Protecting the high seas, protecting a resource without which would endanger all of us, frankly. So anyway, I won't go on, but only to say that that was a very difficult negotiation that between 2017 was adopted in 2024 and close to ratification. All right, here, these are great photos again. So deep sea, it's interesting. Science, this is the one area where science and law really interface and need to interface. And it used to be thought that the deep sea was dead because it was dark, no light. But they have done what's called the Census of Life, massive, multi-billion-dollar marine scientific research, which has engaged practically every country on their ships to go and do scientific research for the deep sea. And they have discovered thousands of new species, and they also discovered that the deep sea, that abyss, the black zone, is not dead after all, that there's a lot of life there, and very interesting life. Not always very attractive, I have to say, a bit scary, but still. There, I also put a photo of hydrothermal vents. Again, going to the science, they actually say that life may have originated from these hydrothermal vents. But why are they there for BB&J? Because they're also important sources for marine genetic resources. All right, marine genetic resources. All right, so the BB&J agreement, I want to make sure to keep track of time. It's through
About 35 minutes.
35 minutes? Okay. Well, before, any comments? Any comments, questions? You don't have to ask questions. You can just comment as well or add something. Yes. Let me get... over there.
Okay.
This, yeah.
Thank you. Thank you, Professor. It is really interesting to see, many, different kinds of environmental agreements under or not under UNCLOS. I'm curious about the UNEP's engagement in the plastic treaty. Do you think there's any advantage or disadvantage in the treaty negotiation for plastic treaty is not under UNCLOS but under UNEP? As far as I understand, and the UN or UNEP is not really big organization, and there are a lot of experts in there, but not really, I don't know, how capable they are to deal with this, manage the negotiation, and then the difference between engage in UNCLOS or not.
Yeah, thank you. That's a very good question, a difficult one, I have to say, in the sense that it probably did make sense for UNEP, only because truly we're talking 90%, 80% of marine plastic is land generated. And they needed to introduce concepts that maybe would have been difficult under the convention. I mean, as you can see, the convention already is showing quite a bit of elasticity. But they've gotten to this whole, first it was the 3 R's, you've heard of that, reuse, recycle, what's the third one? Reuse, recycle, and anyway, something. And then it's 6 R's. I couldn't do 3, I can't do 6. It's 6 R's. And then of course the whole issue of the industry. This is probably one of the Achilles heels, having to deal with private industry. Because the plastic industry, massive, big industry. So I understand the logic, but you're right. I think they've been struggling with it. The UNCLOS has had much more experience. But again, BB&J was not a given either. it has been a long process as well. I mean, really, if you go back, it started in the early 2000s. So it's taken 20 years or more to get to this point. And I think it would, really able leadership, committed states. So it's hard to say. It's a good question, though. Would it have been different, otherwise?
Thank you, and really love the pictures you provided us. Thank you.
Yeah, that's what you'll remember, the pictures. But yeah, thank you. I appreciate that. Any other comments? Personal experiences? Oh? Yes. This gentleman.
Thank you, Doctor. So for the plastic treaty in the previous slide, actually one of the issues that we face, apparently one of my colleagues went to the negotiating session, and then one of the hardest, I would say the hardest aspects for developing countries to accept is that the existence of microplastics, it seems that it is almost entirely impossible to eradicate microplastics. And also the fact that plastics are still used, even if we can see that in this conference room itself, we could see that there is a point or there's a level of development in which developing countries might need some areas of, I would say, relaxation towards the obligations that would be imposed by the treaty itself. But my question is, what do you think of the long-term objective of these kinds of conventions in terms of activities that might need long-term implementation in this regard? Thank you.
Yeah, thank you. So the issue, this is not just for the plastics treaty, this is the whole essence of the common but differentiated responsibility. And for those of you who do environmental law, we know the ozone and the Ozone Convention, Vienna Convention, the Montreal Protocol started the whole idea of differentiating and recognizing that developing countries have the right to develop and so should be able to engage in activities that could be harmful. So the same in the plastics as well, I would understand. I mean, this is something that's an ongoing issue. When it comes to the microparticles, I mean, they found it in fish, they found it, in the Arctic. We may be at a point beyond really being able to reverse some of the impact. But it's difficult to really say, under the law of the Sea Convention as well, it comes up. With climate change, it comes up. Where do we start finding that bridge between where we will pass a threshold of no return, and yet the equities, and I think it is ultimately a question of equity, where the developed countries have benefited, they've created the problem, and now saying, okay, now you have to stop. So I don't think there's an easy answer to that, and hopefully that's why cooperation becomes important, and that's why financial assistance, scientific research, all these become important, though. I really don't have an answer, but it's a very important question. Yes?
Yes, thank you, Professor. This is a very important theme. Pollution by plastic should be everyone's cooperation, like you mentioned, is of everyone's interest, and reducing it will benefit everyone. One example is not only microplastic, like the colleague was mentioned, but also you see marine currents, they transport plastic around the world. And for example, in Seychelles we have Aldabra Atoll, which is a World Natural Heritage under the UNESCO list. And we have found tons of plastic in Aldabra that are not ours. It came from somewhere else.
Yeah.
So in that perspective, and Aldabra is a place for conservation of marine life resources. In that context, everyone's contribution is very important. Thank you.
Yeah, I know it's shocking, really, the transboundary aspect, and it's a classic case of transboundary pollution, which is addressed under the convention. The convention makes very clear the obligation not to engage in transboundary pollution, to give, and if there is the possibility to give, of imminent harm, to give notice. So it is, going back to the question, should it, could the convention have been a better, medium for this? But it used to be on the news quite a bit, but it seems to have dropped off, marine plastic pollution, this issue. But it's a global impact everywhere. So, but let's be hopeful that, again, states can cooperate. But at the end of the day, it is an industry issue. But, okay, we'll get into, again, these advisory opinions. The state does have a responsibility to exercise jurisdiction control over private actors as well. So I haven't followed, I must confess, I haven't followed the language of the drafts for the plastic treaty. It seems very technical. But it would come under. So even if the plastic treaty doesn't, it'd be interesting. Even if we're not satisfied, the convention is there. The convention still is there. And again, from these advisory opinions, we know that the convention, the Law of the Sea Convention, stands on its own feet. Okay? So those obligations cannot be diluted by subsequent convention. That's clear. So again, the plastic remains open to the convention as well. It will not be excluded. So we'll see on that. But good comments? We'll continue. All right. All right, we were at this. So the BB&J agreement, you have what's its objective is to ensure the conservation and sustainable use. Note that, sustainable use. So they're still making sure that there is possibility of exploitation, actually. Of marine biological diversity of areas beyond national jurisdiction for the present and in the long term through effective implementation of the relevant provisions of the convention. So it's under the Law of the Sea Convention, etc. And it applies to areas beyond national jurisdiction. For a long time they would say, oh, the High Seas Treaty, the High Seas Treaty. No, because the high seas is the water column above the seabed. So the idea is that, no, it's not just the water column, or the seabed and below. So that's why it's called the areas beyond national jurisdiction. All right, so I'm not going to go provision by provision, 76 articles. Like UNCLOS is over 300 articles, so these are big, big agreements. But just to give an idea, so what did the BB&J agreement bring? Again, UNCLOS was quite revolutionary for its time, but it was 10 years too soon before other developments took place, such as the famous 1992 Rio Conference and the Rio Declaration, which was important because it introduced new principles, precaution principle. We didn't have common but differentiated responsibility at that time. The notion of common concern was common heritage but not common concern. Environmental impact assessment, it's hard to believe now, we take it so much for granted. A lot of things weren't actually in existence. So importantly, the BB&J agreement started filling not only the gap that existed for this huge area we call area beyond national jurisdiction for protection of the marine environment, filling those gaps. So it included a part on areas-based management tools, including marine protected areas. Now remember, at the time of the Law of the Sea Convention, marine protected areas, they existed but not really very well known. Since then, they've become much more sophisticated. The IUCN, International Union for Conservation of Nature, I'm a member, they have really developed marine protected areas. Remember I mentioned particularly sensitive sea area, the IMO, so that would fall under these areas-based management tools and any other way of managing. We know spatial planning has become important as well. But this is all now going to be done in this high seas, area beyond national jurisdiction, which hasn't been, well, kind of hasn't been done in the high seas. They started doing that in some areas. Some countries have experimented with it. But the difference is this. If, for example, under a regional agreement, countries would get together and say, okay, under this regional agreement that happened in OSPAR for the Northern Sea, we're going to create a marine protected area with binding measures, right? Can't do this, can't do that. The problem is that it would only apply to those countries. That's the issue. But the whole hope for advantage of this BBNJ agreement is that now you could, states acting globally through the BBNJ agreement, hopefully you're going to get a very high level of ratifications, will then start establishing these marine protected areas, and they will be high seas, frankly, marine protected areas that will be binding on all state parties, right? So it's very different. So that's why it becomes important. Environmental impact assessment. There's a provision in the Law of the Sea Convention that alludes to an environmental impact assessment, but it's not clear. But since then, we know environmental impact assessments have become very important for land, right? But also for ocean as well. And so this is an express recognition of that, and it's very detailed. I have to admit, I was surprised that at the end, the states negotiated very detailed technical language in this BBNJ agreement. So not only did they agree to an environmental impact assessment that had to be done for certain activities, the threshold was it wasn't significant harm. They talked about, a lower than significant harm threshold. But they also included something called strategic environmental assessments, which is not universally done. It's done in Europe primarily. And they included cumulative effects. That's really radical. I was surprised because cumulative effects means that when you do an environmental impact assessment, I just, okay, what impact will this activity have on the environment? The idea that you're not just going to look at the one time, okay, I dig in this, one time I dig in, it's going to, make the tortoises leave, they lose their habitat. But they're looking at what might happen cumulatively. So one drop of water may not hurt, but 1,000 gallons over time may hurt, for example. So that's included as well. And I have to tell you, that's really quite progressive. So that's very detailed, very detailed. We'll see how this is all going to be implemented, to be quite honest. Of course, the principle of common heritage of humankind. This was the big debate. For those of you who were following the BBNJ, it was all about MGRs, marine genetic resources. Even though the initiative came from marine protected areas in the high seas, what it really boiled down to is marine genetic resources. A return to Arvid Pardo. Because marine genetic resources didn't exist back then. This is something relatively new. But I tell you, multi-billion-dollar industry. And only a few corporations can do this. That's the thing, too. And so the fight was, does the principle of common heritage apply to marine genetic resources in areas beyond national jurisdiction or not? And guess where the division lay? Who said yes? Which country said yes? Which country said no? Wild guess. It's an easy one. of course, the developed countries said, no, it doesn't apply. And the developing countries said, oh, yes, it does apply. Now, the developed countries had a very technical reason. Again, I didn't mean to go too much into detail on all of this. But if you look at the convention, the common heritage applies, when they talk about minerals, the definition of minerals in the seabed are gaseous minerals or solid, nothing that would, marine genetic resources don't fall into it, to be clear. And so they said, no, not under the definition, and they're certainly not going to amend it. But the developing countries said, sorry, because there's also a part that says all activities in the area come under the common heritage. So it was a big debate, and it's interesting, at the end they came to this understanding. So you do see the principle of common heritage of humankind in the convention, but I assure you they have different interpretations of that. So it's emerged. So we'll see. But put that aside. I have to say the agreement went far beyond what I expected it would in terms of access and benefit sharing of marine genetic resources. And so once it gets into implementation, we'll see, because I think you really see that, one, for marine scientific research, one of the big problems for developing states, they don't have the money to engage in these very, very expensive marine scientific research. These research ships are multi-million-dollar ships. So you need to do that. The marine scientific research is absolutely critical to all of this. So there's a whole new understanding they call non-monetary and monetary benefits. So the non-monetary benefits include joint, research, sharing of research. And then they created something called this clearinghouse mechanism, where all the information goes into this clearinghouse mechanism. So it'll be interesting to see how that will work. There's a place for AI there, I think. So we'll see. And then the system for equitable benefit sharing of marine genetic resources. This is the part of the convention I must confess, I find the most interesting. And we'll see how it pans out over time. Again, use of traditional knowledge of indigenous peoples and local communities. Well, that didn't exist in the Law of the Sea Convention, but now it is in the BBNJ agreement, an important one. And one of the big issues continues to be, unfortunately, it's been how many years since the convention was adopted, capacity building and transfer of marine technology. That was hotly negotiated. Why, you may say? Because the developed states really didn't want the language shall. They don't want it to be binding. They say, no problem. Of course we're going to, support, give capacity building. Of course we're going to do that. But they want it to be on a voluntary basis. So again, the language is a compromise. They still have the shell, but it's not a really hard shell. But I think at the end of the day, it's all about good faith. And so, if we have to show like the census of science, the research they did, that was truly a cooperative research where all states benefited from that. So that should continue. Let's see. The new institutions were introduced, bodies. One thing that they didn't have under the Law of the Sea Convention, because at that time it didn't really exist, was this notion of conference of the parties. Now we're all familiar with that. So that's something that after 1992, with the adoption of the Rio Conventions, the environmental conventions, and the reason, it was a very practical reason. The way the environmental conventions were structured was as a framework, the basic principles, basic obligations, and that just made it easier to negotiate. And they realized, let's see what happens over time. And so power was given to the states through the Conference of the Parties to adopt decisions to basically implement the agreement. We didn't have that in the convention, so the first time, and not really in the other implementing agreements, so the first time now we have a Conference of the Parties, and the Conference of the Parties will be the one deciding about marine areas-based management, how they will be done, benefit sharing, access, all of these things will be done by the Conference of the Parties. Also, Implementation Compliance Committee. We had, of course, in the Part 15 of the Convention, I mentioned, very elaborate compulsory dispute mechanism part. But again, after the convention, there were new developments, particularly in international environmental law. And they said, okay, well, it's not only about dispute settlement. It's also about facilitating compliance. Because at the end of the day, with the environment, really what you want is to make sure that states implement their obligations so that the objective of the environmental treaties can be met, right? That's what you want. And if they're not, maybe they need help, maybe they need, so it's not about punishment necessarily, it's about helping as well. And so there's a difference between, implementation, compliance, and enforcement and dispute settlement. And just for those of you who may be following climate change, there was the Kyoto Protocol. And the Kyoto Protocol actually had both. It had a compliance committee that also had an enforcement, but that was for developed countries. So they're a big penalty to those developed countries under the Kyoto Protocol who didn't meet their emission reduction commitments. I'm going to fast forward the advisory opinion just by the ICJ. If you followed it, what did it do? Just amazing. It resuscitated the Kyoto Protocol. And so Kyoto Protocol is not dead, nor are the obligations. Very interesting. Anyway, so this is quite common in environmental law treaties, but we didn't have this in the law of the sea. So now the BB&J agreement has a compliance committee, a compliance mechanism, with the understanding that the whole idea is let's help states where they need help to be able to fulfill the objective. There is absolutely no punitive aspect to this. So that was made clear. One thing, too, so I have to say it's interesting when you look at this BB&J agreement. So it incorporates Part 15. And that remains the same. But it's also added some new things. For example, disputes of a technical nature. This is something they were inspired by from the fish stock agreement. So there's a whole process now. If there's a dispute of a technical nature, then they can create an ad hoc expert panel. Right? So it's a way, again, to try and resolve issues that will facilitate, ultimately, implementation and meeting the goal. So they don't have to resort to binding procedures. And then it also allows for non-parties. I'm from Turkey, we're a non-party. And I have to say Turkey's actually considering becoming a party to the BB&J agreement. And so while Part 15 applies to the convention, it does not, becoming a party doesn't mean that you're prejudicing your position, such as certain non-party countries, on the convention. So they took that into account as well. Okay, so this brings us to climate change and challenges for international law. But before we go into that part, the exciting part actually, then I'll wake you up more in the afternoon. Any other comments about BB&J? There's a lot, but we have limited time. So I'm just trying to give you a flavor of the BB&J agreement, which really, again, exceeded my expectations on that, because these are very controversial issues. You have a division amongst countries, different views. Particularly when it comes to marine genetic resources, the economic part of this is absolutely, essential. So we'll see how it all works out. We're just a few close to the ratification, but the goal is to have a high level of ratification. So, any comments on that? Yes? Sumi. I see your name. Yeah, I couldn't see the others, so. Huh? Oh, yeah, Alco.
Thank you so much, ma'am, for this great presentation. This is regarding to the last slide of this presentation, which is with regards to the obligation to settle disputes by peaceful means. So now that you discussed that a lot of provisions under the BB&J, they are still, like you mentioned, it is shall, but again, not a very binding shall, but kind of, we'll have to wait and watch how it goes. Provisions regarding capacity building or knowledge sharing, we're not sure how strictly the developed nations would take it. So with regard to that, how exactly it's given that parties, they shall settle their disputes concerning the interpretation or application by negotiation or whatever of their choice. So in that aspect, do you think this article will be very helpful to kind of solve the objective of this treaty, this agreement as such?
Yeah, thank you. It's interesting because when you think about it, how often are the dispute settlement provisions actually used for issues such as this? A lot of the time I say, like, under the Law of the Sea Convention, you have a lot of concerning the maritime boundaries, sometimes others as well. They used to have a lot of prompt release for detained vessels, etc. This is why here I think the compliance, to answer your question on that, because it's important. How can you call on a state? And this is, the difference in power between, the rich states, who can exert influence in different ways. But this is where the compliance can come into play. And so it's a less formal way, and it's not meant to be adversarial in terms of a method to perhaps call upon if states feel that certain obligations, they are still obligations, are not being met. But the peaceful settlement always remains. That's pretty well customary international law. It's in the Charter, peaceful settlement of disputes. But I think the real question is, how do we make this really a successful, all aspects of this BB&J agreement successful, short of actually going to court, right? All right, well, we can climate change in the ocean just before our break in 5 minutes. Well, there's so much to say about that. So, when the Law of the Sea Convention was negotiating, and it seems like once upon a time in the distant past, climate change, even though the scientists were working on climate change, but it wasn't an issue of concern. And I think that's really important. And so, it never came up in the negotiations. It just was not an issue. However, a few years later, it did become an issue. And I have to say, I always point out that, so it was Ambassador Pardo, this very, the small island state of Malta, that launched the whole process that led to the United Nations Convention on the Law of the Sea. And I hope you have an appreciation of how important a convention that is. But guess what? Well, it wasn't Arvid Pardo, but it was Malta again. You know, this little island of Malta has been very influential that launched climate change at the UN General Assembly. And so 1988, and then 1989, thanks to Malta, resolutions were adopted that for the first time recognized climate change as a common concern of humankind. Right? But it's a shame that, you know, we didn't take more actions back then. We would not be in the situation we are right now, to be quite honest, 1988. But now we're going to look at the ocean, all right? So again, the ocean is very neglected. We're very terrestrial-minded, perhaps because we live and work on land. But the fact of the matter is, the Earth, as they say, is blue, right? When you look, it's blue, it's ocean. And that ocean is existential for our climate. Without the ocean, as we have it today, and that's the problem, it's changing. It is responsible for the climate we have. And I'm not a scientist. You know, someone who has a background in marine biology who will be lecturing you is Catherine Amerfar. So she would probably explain this. But this is that great Gulf Stream. It's the belt. And it picks up warm water from the Pacific and eventually, through currents, brings that to the north. And that is why the northern part of Europe would be much colder but for this current. Do you know how long it takes for this current to go around the globe? Take a wild guess. Maybe you already know, though. Up to 1,000 years. Yeah, amazing, huh? I know. And guess what? Because of human activities, scientists in recent years have discovered that it is slowing down. And that is because of melting ice. It's slowing down the current. And that can have, extreme consequences for the climate. Meaning, some countries could freeze because if that stops, it just... So, to make a long story short, I'm not a scientist, so I'm not going to get myself in trouble by getting too scientific. But this I know, that this current that goes around the world in centuries' time, transporting water, is critical for the climate we know today. If it changes, our climate changes. And so what? Okay, so it's a little hotter or warmer. Why should we care? Why does it matter? Why do we care about the climate? Well, agriculture, right? Droughts. I mean, without the climate we have already the climate has changed. I mean, you know, deserts that were once tropical forests, but the difference is this: the climate has always changed. The Earth. I mean, if you look at geological history, I mean, for millennia, I mean, the Earth is like 6 billion years old, so it's not been the same Earth and same climate. What's the difference? It is a difference that we have changed. They call it anthropogenic activities. And to be honest, a lot of it has come from the developed world, of course. I mean, that's the truth. And this was recognized by the recent ICJ advisory opinion, who recognized that 58% of emissions today, came from the industrialized countries. So that's it. But the ocean, okay, not only because it's a current, but again, without the ocean, it absorbs carbon dioxide. And we know most of the climate change concerns we have today, you have the 6 greenhouse gases, but carbon dioxide is really the major, coal, fossil fuels, this is the major concern. The ocean has been absorbing carbon dioxide for centuries. Almost a quarter of carbon dioxide emissions in the atmosphere has been absorbed by the ocean. Also, heat. So you know climate change, this whole greenhouse gas effect, as the greenhouse gas is going up, it creates this enclosure that's trapping heat, and they call it the greenhouse gas effect. So we're always thinking of the atmosphere, but it's actually the ocean that has been absorbing 90% of the excess heat in the atmosphere. Well, where do you think is that? I mean, so what's not impacting the ocean? Of course it is. Major. And this is where we are right now. We are at that critical threshold where the ocean is pretty well peaked out, and it's become dangerous, and this is what we're going to look at. So to make a long story short, the ocean is... Oh, it's time for a break. I apologize. I got carried away. All right, we will continue with this. So we get a 20-minute break.
Thank you very much.